Welcome everybody to our event. We're very happy to have you. I think we're going to have a fun and good event here about some serious topics in a fun way. Just to welcome everybody, my name is Tanner Baird. I'm the Executive Vice President of the Texas Federalist Society. To just give everybody a quick plug for the Federalist Society, we are a legal group that believes that it is emphatically the province of the judiciary to say what the law is, not what the law should be. We believe very strongly in free and open debate of ideas, and we live by the mantra, debate, discuss, decide. We think that's how people should come to their own conclusions on important legal issues. And if you're interested in joining the Federalist Society, you can go to fedsoc.org/join to join your local chapter. You can also reach out to our membership chair, Henry Humphreys, whose email will be dropped in the chat. And we'll also, or you can contact, since we are co-hosting with Baylor here today, you can go to fedsoc.org/join, join the Baylor chapter if you're associated with Baylor, or reach out to their membership chair and officer team in order to join their chapter as well. We also have, we've got in the chat there Henry's email. We also just want to remind everybody we have another event coming up this Thursday on crony capitalism. That will be this Thursday from 5 to 5:30, and I would encourage everybody to go there. I would encourage everybody to follow the UT Federalist Society on Instagram, Twitter, Facebook, and we have a YouTube page as well for information about upcoming events. And with all that said, I'm going to go ahead and introduce our moderator today. So Professor Melissa Wasserman will be moderating our Tiger event today. Professor Wasserman joined the University of Texas Law faculty in 2016. Her research focuses on the institutional design of innovation policy with a particular emphasis on patent law and administrative law. She holds a PhD in chemical engineering from Princeton and a JD from NYU Law School. Professor Wasserman was both a National Science Foundation Graduate Research Fellow and an American Association of University Women Selected Professions Fellow. She is also formerly an academic fellow and lecturer at the Petrie-Flom Center for Health Law, Policy, Biotechnology, and Bioethics. And if that weren't impressive enough, she's also a phenomenal torts professor. So with all that said, take it away, Professor Wasserman. It's all yours.
Thank you so much, Tanner. So I just want to start by thanking, obviously, both the FedSoc chapters at UT and Baylor for organizing this, what should be a terrific event, and thanking both of our panelists, Rob and Stephanie, for agreeing to take the time out and share your knowledge with us about a really interesting and important topic. So I'm just going to go ahead and start by briefly introducing our panelists, and then I'm going to turn it over to them. They're each going to talk for maybe about 10 to 15 minutes, and then we're going to move to Q&A. So I'll throw out some questions, but we would also love for the students to just go ahead and type your questions in the Q&A, and as they come up, I'll just read them off, and we can just continue the discussion. So Stephanie Clark is a member of Nossaman LLP Environmental and Land Group in Orange County, California. She advises clients on a variety of land use and environmental matters, including matters dealing with the California Environmental Quality Act, the Endangered Species Act, and the National Environmental Policy Act, and the APA. She holds a JD from the University of Washington School of Law and is a frequent national commentator on the Endangered Species Act issued through Nossaman's Endangered Species Law and Policy blog. We also have Rob Henneke here today. He serves as the General Counsel at the Texas Public Policy Foundation. And before joining the foundation, Rob served as a county attorney in Kerr County, Texas, and as the Assistant Attorney General in the General Litigation Division under the leadership of Texas Attorney General Greg Abbott. So Rob appears regularly on national news programs such as Fox News and MSNBC, and his legal commentaries have been published in USA Today, the Wall Street Journal, the Washington Post, the Washington Examiner, and The Hill, among other national publications. And very importantly, Rob received his law degree from UT. So with that, let's go ahead and I'll turn it over to Stephanie, where we're hopefully going to learn a little bit about the laws and regulations associated with breeding exotic animals in captivity. Go ahead, Stephanie.
Thank you for that lovely introduction, Professor Wasserman. So as she said, I am located in California. One of my wonderful Texas colleagues was originally scheduled to be here today, but she very recently had a baby, so she had some competing commitments. So as most of you probably did, I got into the subject of Tiger King and the ESA by watching the show early on, I guess about 6 months ago. And it's such a fascinating look into the world of these big exotic cats and the people that keep them either as private zoos or as essentially their own personal menageries, and how those cats are regulated. And they really don't get into the regulation until later in the show. So if you're only a couple of episodes in, I highly encourage watching the rest of the show. There's some interesting little tidbits as the show moves on. But one of the main questions I had coming out of that show was, are people really going to understand how the ESA, which is primarily this statute that regulates the taking of animals and the taking of these protected animals across state lines, in the context of this man that primarily just captive bred these animals? And the show didn't do the best job of explaining that, so I actually ended up writing an article about it. And for those of you that are not familiar with it, it is a 1972 law that was passed. It's the national framework for how endangered and threatened species are protected and treated within the US. And sorry, I'm getting distracted by the chat pop-ups. So that doesn't very clearly provide a hook for regulating these species that are very clearly not endemic to the United States. But the ESA is also the primary vehicle through which the Convention on International Trade in Endangered Species, or CITES, is implemented in the US. And the way that's done is CITES has these two schedules of protected species. They're basically two different levels of protection that are very similar to endangered and threatened under the Endangered Species Act. And if species are listed on one of those two lists, they're also protected under the ESA. That's sort of the very broad overview. I can go down a lot of different rabbit holes. But that's the broad overview of how the Endangered Species Act regulates these species. For tigers specifically, tigers were listed as an endangered species under the ESA. They're also listed under CITES. But under the ESA, it was originally 4 specific subspecies of tigers, and that had to do with their specific genetics and their regional diversity and whether those populations ever interacted. In the US, if you have a species that goes across the whole of the United States and has some range but is still considered threatened or endangered, the way this works is if you have a population of that species that stays sort of by itself and doesn't interact or have genetic exchange with any other populations, but is still really important to the overall range of the species, it's called a distinct population segment, and that can result over time in subspecies coming about where they have actual genetic markers that are different. So that's how the tiger was originally listed. It's obviously not endemic to the United States, but by the year 1972, you already have some tigers in captivity in the United States. Because private zoos are a long tradition in the United States in all different parts of the United States. So the way that those types of captive bred and captive held protected species are sort of justified and regulated under the ESA, they're not really regulated. They're not super closely regulated initially in 1972 when the ESA was passed, because the intent of those private zoos, and obviously the larger institutional zoos, is to teach the population. Educational purposes, people get to interact with these species, they start caring about them more, they understand their needs and their specific situation, being endangered, threatened, on what sort of global scale. a little bit more. And that's sort of the justification for allowing these institutions to continue to keep these animals. In the biggest change, and if you've watched Tiger King all the way through, you'll hear this referenced a couple of times, for the tiger specifically, was in 2016, there was a regulatory change that actually brought crossbred tigers, so these hybrid species that weren't a clear genetic subspecies, they weren't a Sumatran tiger, they weren't one of the other breeds of tigers. I don't memorize all the subspecies, unfortunately. But it brought all of these crossbreeds under the auspices of the ESA, which means these crossbreeds never be released into the wild. They could never be really used to prop up these international populations of tigers that are supposed to be the ones we're protecting and trying to up the numbers of. They were now protected under the ESA. And what this means is these private zoos now were more closely regulated on how they could keep these species, specifically the crossbred species that weren't a specific subspecies of tiger. So they had already been slightly regulated. There are a couple different acts outside of the ESA. You'd be surprised once you start going down the rabbit hole of what federal laws actually regulate captive bred and kept large wildlife, how far you can go down that rabbit hole and how many laws you find. But there are registration requirements for these private zoos that keep these big animals on a federal level. If you're going to move an animal in cross-border trade or even interstate trade, like you're going to sell a cub to someone else, there are registration requirements, there's restrictions on how that's done, there are restrictions on when that can be done. And I'm sure Rob will be able to talk a little more about the Lacey Act, but that is another one of the big regulations for these types of animals. So for the ESA, what all of this regulation meant and what it meant in the context of Tiger King was all of these hybrid tiger cubs that he now had, he had been selling those across state lines. And once those are brought under regulation by the ESA, you can't do that anymore because all of the subspecies of tiger are listed as endangered. And what endangered means, and even under the most recent regulatory changes to the ESA, means you can't trade those species across state lines with very, very narrow and specific exceptions. And trading them for private zoos really doesn't fall into any of that. So that is the 30,000 foot view. In the context of Tiger King, he was actually, there are three sort of categories of violations of the ESA he was ultimately convicted of. The first was killing 5 tigers, which is constituted unauthorized take. So they're considered endangered species. The primary vehicle for the Endangered Species Act to protect species is through the take clause. It's, oh my God, my brain just died. Section 9 of the ESA in take is defined really broadly, but obviously includes hunting, shooting, killing. So he was convicted on, that was counts 3 through 7 that he was convicted on. And then he offered tiger cubs for sale across state lines. That was count 8. And then he did in fact sell tiger cubs across state lines. And that was counts 9 through 11. I think that may have also been a Lacey Act violation if I'm not remembering that incorrectly. And the very last one was that he submitted false documentation for lions and tigers sold all over the United States. And that was counts 12 through 20. So a lot of different counts there. And he was convicted on all of the counts from 3 through 20. So long laundry list, and a big chunk of those were ESA violations. With that, that very long introduction, I'll turn it over to Rob.
Well, thank you for that, Stephanie, and Melissa, thanks for moderating. Certainly to both the UT and Baylor FedSoc chapters. Guys, thanks for the invitation. This is a fun event. Again, my name is Rob Henneke. I'm the General Counsel and Litigation Director of the Texas Public Policy Foundation. We are a nonprofit think tank based here in Austin, a conservative think tank. We focus on limited government issues, where we focus on restoring constitutional rights, free market, economic liberty type areas. And I run the litigation center, where we try to defend property rights and individuals and businesses by challenging unconstitutional action, with the goal of not just putting government back in the box, but making that box smaller as we claw back the past 100 years of jurisprudence that have slowly eroded our constitutional rights. And I say that as an intro and a short shameless plug, because we do clerkships. I have 5 attorneys who work with us. We have year-round clerkships, fall, spring, summer. They're in person if you've got some extra free time because you're doing virtual classes and miss being around people. Please check us out, especially here during the school year. But I do all of that to frame, and if Stephanie was at 30,000 feet, I want to go up to 50,000 feet for a minute, because let's start off by looking at the proper role of government and what we're talking about when we're framing these federal environmental statutes. That, you know, as a constitutional basis, our federal government is one of limited and enumerated powers, and those powers are set forth in Article 1, Section 8 of the Constitution. The grant of power to the federal government was specific and limited. So we have grown way past that. But conceptually, when we talk about these statutes, when we talk about the Endangered Species Act, when we talk about the Lacey Act, which deals with kind of the commercial display in some ways of these type of animals, all of these federal laws, every federal law is required to track back to a power that's delegated to the federal government in the Constitution. And where you have seen the justification for the Endangered Species Act specifically has been through the Commerce Clause, the power that was granted the federal government to regulate commerce amongst the state. Interstate commerce is supposed to be the federal basis for this power. And so long has the federal government kind of justified its power to regulate species under its interstate commerce powers, to where you have these across state transactions of these species. Now, as we see from cases like this, I think it sometimes gets somewhat tenuous on that connection to that underlying federal power. Here in the last 5 years at the foundation, we've been litigating an Endangered Species Act case that has involved this cave spider species that only exists in one county in central Texas. It's about the size of the nail on the end of my finger. It's not bought or sold. It doesn't cross state lines. It has no commercial value. It doesn't interact with other species, and yet has been regulated by the Endangered Species Act for the last 20 years. And in our lawsuit, we challenge the constitutionality of doing that, because in this situation, the regulation on private property involves a purely intrastate species that has purely intrastate significance. And so we've said that falls outside of the scope of the federal government, as the Endangered Species Act has been expanded through the administrative, state, and regulatory power to be much broader than it really was intended when it was first adopted. I mean, the Endangered Species Act came about during kind of the 70s, when you had the rise of these environmental statutes. But the Endangered Species Act initial focus was the bald eagle, was the grizzly bear, was these big poster type species that covered wide ranges of the country and were being threatened with extinction for various factors. And now we've gotten to be so beyond that in some of these issues that I think when you're talking about ligers, when you're talking about subspecies of crossbred tigers and big cats, you're really getting away from some of the intent. And as part of the context of this too, that fits in the discussion, I think we have to recognize that within the constitutional limitations of the Endangered Species Act, the stated purpose of the Endangered Species Act is recovery of species. I mean, that's written into the statute as part of the goal there. And so it's interesting, so you can understand the original policy reasons for not wanting to kill species. Okay, you know, you have less of them if you kill them, if they're endangered, if they're extinct. But it's weird when that works in this context where you actually have these organizations like the Joe Exotics Ranch or Carol Baskin's thing that are actually expanding the population of these species and are doing so, breeding them in a way that they're never going to be able to exist in a wild type status. But where you are propagating the population of these species that wouldn't exist otherwise, you know, to what extent does that still fall within the kind of protection activities? And I say that because I think it's important from a policy perspective in looking at the Endangered Species Act, and you see this with the Tiger King situation. The Endangered Species Act is really a punitive statute. It punishes you if you do certain things with the species, if you cause, if you destroy. And I think one of the reasons why the Endangered Species Act has really not been so successful is because of that punitive focus in the act. Whereas were we to revise the Endangered Species Act today, maybe the better and more proper way to address conservation of threatened and endangered species would be in a positive way, in a way that doesn't restrict what you can do on private property rights, but maybe creates incentives for people to want to have conservation through tax credit, something like that. Would we have better results if instead of being afraid of enforcement against you, property owners would proactively seek to go out and to preserve habitat and preserve species because they had a financial incentive to do so? Maybe that fits in better in the modern context when you have some of these animals that have been bred and so forth, these non-native species that now exist and are actually flourishing much better in the United States than they actually are in their natural habitat in other parts of the country. The last thing I'll say in framing this discussion is, I think in looking at the proper role of the government and what the Endangered Species Act, we have to put into different buckets what we saw going on in Tiger King and recognize where those things exist. A lot of the focus, you know, was, you know, some of the things were involved animal welfare and also public safety. You know, animal welfare, and certainly my earlier role as a prosecutor, I dealt with some of these dangerous wild animal type issues. It can really become a problem given the type of cost that it takes to sustain an operation like this, and where there's been situations where people have literally run out of money to feed their collection of tigers or something like that. And, you know, then you have situations like was alluded to in Joe Exotic where they weren't having enough food to feed their you know, their tigers. And that, you know, ties into public welfare thing where, you know, what should be the safety regulations? You know, how do you address that? How do you address people that get hurt at a job site? Or, you know, what happens where there's been, you know, past instances where people have just like opened the cages and quit and walked away. But I say that because I don't know that that's really a proper role for the federal government. I think that those areas of animal welfare and public safety have been traditionally reserved to the state. So where the federal government is coming in and taking, you know, interest because of those issues, you know, I would suggest has gotten beyond the intrastate commerce power that is supposed to be the limited justification for the Endangered Species Act, and kind of shows how, you know, these statutes that were adopted 40 years ago don't necessarily translate to the, you know, the evolution of policy and animal and you know, where that exists in the modern society. So with that intro, I'm looking forward to a great discussion today.
So Stephanie, do you want to add anything before we start Q&A? So I don't know as much about the Endangered Species Act, so I'd love to get your sort of take, right? If you agree with Rob's kind of the historical sort of evolution that it's gotten away from its roots, which were much more focused on sort of different types of animals than today.
Yeah, I mean, the true impetus of the Endangered Species Act when it was passed in the early 1970s was really these charismatic megafauna, these big poster child kind of species that the US started seeing disappearing, in particular the gold eagle, which is also the subject of its own regulation, the Bald and Golden Eagle Protection Act. But those kind of species, it was really aimed at protecting these as part of the American heritage. These were the species that really, when you talk about them, people think of the United States and they think of them as the poster animals of the United States. And it really did expand over time, initially with some amendments. I'm going to get the year wrong on the amendments to the Endangered Species Act. I believe it was in 1974. But that started a little bit of an expansion, and a lot of the expansion that's happened after that has been primarily regulatory, and then has also occurred through case law. One of the biggest expansions of that, and where you can kind of see the tension between intra and interstate, is the Fifth Circuit's 2003 case, and I actually looked up the name because I knew I was going to get it wrong. It's GDF Realty Investments versus Norton. And that was a case where there was entirely an intrastate impact to species. It wasn't a species that was moving in interstate commerce. It didn't really have any commercial value whatsoever. It was, I believe they were spiders and beetles. And it was a housing development that was causing these impacts. And the way that the court came to say the ESA, yes, it does properly regulate this kind of development, and this can properly cause a take under the ESA, even though it's all intrastate, it's not moving across state lines, was that the housing development could have interstate effects. It was a little bit of a far reach, but that's where you really see how far it's expanded. And then after that 2003 ruling, you have more of these regulations where there are regulations that seem to step beyond the bounds of the Commerce Clause.
And I think it's an interesting point. I'm very familiar with that. And that dovetails into the law and kind of the federalism discussion that we're having here. That was the GDF Realty case in 2003 was under a pure, commerce third prong Lopez Morrison examination on that. But I think it's an open question as to whether that still is the case law today, because you've had the late Justice Scalia's concurring opinion in Raich, which was the marijuana case, where you had someone who was growing marijuana in state, I think for their own personal consumption, and they were prosecuted under a federal law, and so they alleged that, hey, this is outside of interstate commerce. And the Raich opinion, which has been adopted by the Fifth Circuit as the law of this circuit, and also as ratified by the majority opinion in NFIB Sebelius, suggests that really it's not just a pure question of commerce, but you have to look at it within the lens of the necessary and proper clause, which is more so, which I think is correct, and I think raises a higher bar as far as, to be constitutional, is it necessary for the effectuation of a federal regulatory scheme? And you look at that specific critter or whatever for this context, and is that a proper role for the federal government that doesn't usurp the power that's constitutionally reserved to the states and the individuals? And so what Stephanie said is directly on point, but I think that is an open question, and certainly more recent Fifth Circuit and Supreme Court cases have suggested that the past federal reliance on you know, if we can tie it to anything commercial, then that means it's constitutional, is not necessarily the case. And it's, I think, likely that we're going to see another case here in the future that's going to further limit or define the limitations of federal Commerce Clause powers, as was done in Lopez, as was done in Morrison. But, you know, as you see a greater expansive administrative state, then that necessary and proper clause question is one that's going to have to be examined. And I think then in that lens, a lot of what the federal government does in justifying the exercise of its power is going to be challenged and potentially limited.
So let me ask, I think how Rob was describing what was the concern as Tiger King is what I got from watching it as, you know, just someone who knew nothing, right, about exotic animals before this, right, which seemed to be this idea that it was definitely animal welfare, right? It was this sort of idea that you had these cubs, and after they became 12 weeks, right, they weren't that useful, and there's concern that they're, you know, being killed or being treated, you know, harshly, right? So do you, Stephanie, think that's sort of an appropriate use then of the Endangered Species Act if you had because I at least thought from the Tiger King, there was the interstate aspect, right? I was assuming he was selling the cubs across state lines.
Yeah, and I mean, that is one of the charges he was convicted of. But in terms of animal welfare, there are actually other laws that deal with animal welfare. There are some federal laws, whether or not that's really a proper role for the federal government for these privately owned zoos, where the concern really is a purely intrastate concern at that point. That's a different question, but it's really not the ESA's purview, particularly where you have this question of whether or not a species is being regulated as an endangered or threatened species properly, where he's got like these hybrid tigers that aren't a genetic subspecies. Some of them are ligers, which isn't even a naturally occurring species. It's probably not a proper role for the ESA, because the entire purpose of the ESA is to enhance the propagation of these species in the wild, to enhance their populations, and to really pull them back from the brink. And if you have these crossbreeds, you're not doing that.
So I'll throw this to both of y'all, but it's like, what are they doing? And just let me walk into this, but to have the question of being, would it be better? Let's assume that the animals are not being mistreated. Let's assume that they're being fed, you know, and that they're being treated humanely. Would it be, from a public policy perspective, better for these animals to not exist, or for them to exist in this kind of commercial, breeding display type thing? And I don't really have a great answer to that, but I think it touches on what we're talking about. It reminds me of the example of several years ago, you had the horned scimitar oryx species, which is an antelope. It's an African antelope type species, which has nearly become extinct in Africa, but it has been brought over to the United States, and especially like in Texas, where you have a lot of exotic hunting type operations. The species had been bred and it had been grown and was actually abundant and flourishing, and there was so many more of those that existed in Texas than existed anywhere else in the world. The species have been brought back, albeit in this captivity, and a lot of times for the purposes of hunting the species. It got to the brink where here in the United States, the Fish and Wildlife Service was about to regulate the horned scimitar oryx. And the owners of these herds in Texas basically came and said, if you do this, the day before this regulation goes into effect, we're going to kill every single one that we have. We can't afford to have them if we can't use them for commercial purposes. And the commercial purpose on these is hunting. We can't afford to feed them. We can't afford to keep them on our land. And so we will wipe out all of the horned scimitar oryx in Texas if you proceed forward to put them under federal regulation. And at the time, a lot of the animal rights activists were the ones that said, do it. We would rather these animals not exist than to allow them to be hunted. So their pressure was, yeah, that's fine with us. Ultimately, the Fish and Wildlife Service pulled back. They did not regulate them. They still exist in bred captivity here. But from a policy perspective, I'd love to get y'all's thoughts. Like, is that good or bad? Is it good or bad to, breed tigers and to have them and display them in this commercial type way? Or is this an abomination that should just be completely outlawed? What do y'all think?
Well, I'd love to hear Stephanie. You go first.
Oh, I was going to say, I don't know that I have a good answer to that particular quandary either. It's where you come at from in terms of that. Trying to think of how to say this. I'm getting my mouth way ahead of my brain here. The perspective you come at that issue from is going to be very closely tied to how you conceptualize the purpose of these different protection statutes. Is it to propagate these species in the wild, in their natural habitat, or is just having them in existence at all its own type of good that you should be furthering? And I don't really have a good answer to that. And I think there are very polar opposite views on that. If you're just looking at it from a pure global biodiversity perspective and seeing biodiversity, its own existence as being its own good that we should further, then yeah, having these species at all, that is absolutely a policy that you should pursue, and having them in captivity or in the wild doesn't really matter as long as they exist.
And I think too, you just have to recognize the commercial aspect of this, and how much is involved, and even in the conservation aspect of it. I mean, look, compare Joe Exotic's operation with Carol Baskin's operation, and Joe's was more like going to malls and showing off tiger cubs. But let's not also avoid the fact that Carol Baskin's operation, even though it operated as a nonprofit, was a very lucrative type operation. I mean, the millions of followers that she had on social media generated a lot of revenue and, nonprofit status, and, the facility she had there. And so, in some ways, they were both kind of commercial operations that both existed to, have publicity and revenue and so forth from having these species. I think if you look at it from an objective way, it's hard to separate the core actions of what each of those were doing. And yet, the camps are so firmly entrenched on either side, and each of them think that the others are monsters, but think that themselves are operating, correctly and properly and purely. And I go way back in the memory, my memory to think about first year property, and thinking about the ferae naturae, the native species that don't belong to you until you kill them. But also recognizing in Texas that non-native species typically are the property of the property owner. And you have large facilities in Texas, you have high fences, you have these high game, these game operations there that have these non-native type species. And should we have a third exception? Should we have protection of endangered species where they exist and still exist in the wild? should we have, recognition for, native species and property rights and that type of property law? But does what we're talking about here kind of throw into a third bucket of none of the above, where you have these hybrid bred, can't be released in the wild, but yet exist type operations? And, what are we furthering by, either the existence of these operations or the limitations that are put onto them by the federal government in the first place?
So let me ask one last question, and then we'll open it up, and hopefully the students will jump in. So my guess, right, was what, or at least from watching Tiger Kings, right, what Carol Bassett's claim was as to why she was different, right, is because she wasn't breeding the cubs, right? She wasn't, and so I totally agree. They were both very commercial aspects, obviously, social media, et cetera, lots of money at stake. But it kind of leads you to the question where you started your question by saying, assuming they're not mistreated. What happens if you think they are being mistreated? Because one question I had from watching Tiger Kings is it even feasible to run these sort of exotic pet shows that involve these tigers in a financially kind of successful way if it always comes up that once the cubs are past 12 weeks, right, they just become incredibly expensive to run? It just seems like they had to kind of get rid of the cubs. So if you have something where it is being mistreated, right, I'm curious what you both think is kind of the best way to move forward if the Endangered Species Act isn't really meant to deal with that. Would you just want state regulations to come in? And why then do you think we didn't see any of that going on in for Joe Exotic or, other sort of exotic pet zoos, right, where there is supposed mistreatment of animals?
So the state level of regulation for exotic animals really does vary quite dramatically from state to state. I'll give you an example. In California, there are state laws that actually regulate how closely related your domestic cat can be to an African wildcat. And there are actually crossbreeds of cat that sell for hundreds and thousands of dollars. They're called savanna cats, and they are typically bred in their first generation between a domestic cat and this African wildcat called an African serval. You cannot own those first generation cats in California, but in a number of other states you can, and there are very large breeding operations that are quite commercially successful that breed these cats, because you can get in California like a fourth or fifth generation cat because that's far enough away. But the difference in regulation is so wide from state to state. And that really has to do with the state looking at its own environment, its own biodiversity, and figuring out, okay, is this a risk? And does this make sense for our state? And that's the type of state level regulation that when the ESA was first implemented, I think it more envisioned. There are pieces of the ESA that do envision more state regulation and the state being more involved in the protection of these species than the federal government. And over time, it's sort of walked away from that. But in terms of whether the welfare of the species should be a state level regulation, I think it absolutely should. That really is a state level consideration. Is that something that the state as a whole cares about? Is that a policy goal for the state? And that is going to vary dramatically from state to state. And if these species are primarily just remaining intrastate, they're not themselves moving in commerce, being sold, things like that. And they can't really be used to further the stated goals of the ESA, which is propagation of the species in the wild. It doesn't really seem like it is a proper place for the federal government to regulate uniformly across all of the states.
And I agree with Stephanie on where we're landing on this. And I think two things. One, I cannot stand animal abuse. When I was a prosecutor, I prosecuted it. And when I think of animal abuse, I think of cases I saw where you would have an animal that's chained outside in August in Texas, no shade, no food, no water, or when you have an animal that's been starved and you can see the ribs, or when you see some of these, breeding operations where you're just literally just wearing out animals by just breeding them. I mean, that's when I think of animal abuse, and it's horrid and I hate it and it makes me angry and it shouldn't be tolerated. And I think it should be addressed at the state and local level. I'll also say, in terms of the big cat and the Tiger King thing, I don't get it. I don't want to have a tiger. I mean, I wouldn't own one, but there's people that feel, passionate about that. It's not the culture that I would, choose to be in. But I say that, I wouldn't say that just mere humane possession of an animal is abuse. I think if the animal's being fed, if the animal has sufficient room, if the animal is not being physically abused, those kind of things. Yet it seemed to be a perspective from like the Carol Baskin trade, that there was something inherently abusive in petting. Where that was abuse in and of itself, even though nobody was punching the tiger cubs that were petting them or something like that. So it's hard to define, but I think that where that should exist should be policy determined at the state level and executed by local law enforcement at the local level, where we're prosecuting and preventing cruelty and protecting safety, but to a certain extent otherwise just leaving folks alone when they're not crossing those boundaries of cruelty, abuse, and public safety.
So we have one student question that's come in. So let me go ahead and read this. It's from Claire. She says, do you have any thoughts on how ESA regulation will change under COVID? Specifically, the EPA is currently being sued with regard to its March 26, 2020 memorandum entitled COVID-19 Implications for EPA's Enforcement and Compliance Assurance Programs that gave private industries discretion with determining if they continue to comply with monitoring and reporting requirements that are, quote unquote, not reasonably practical due to COVID-19. Any thoughts on this?
So that particular memorandum actually doesn't have a lot of ESA implications. It's primarily geared towards air quality and water quality type monitoring. It's particularly relevant for the Clean Water Act, actually, and for reporting requirements associated with discharge, for example, from power plants and things like that. ESA regulation has, to be frank, hasn't changed very much under COVID. There have been some major policy revisions having to do with critical habitat designation, but the reporting requirements really haven't changed.
Rob, did you want to add in?
Yeah. Enforcement, what comes to mind there is, they say that, what is the way, what the ESA has led to has been for many, property owners, a policy of, shoot, shovel, shut up. That because of the punitive nature of the Endangered Species Act, that when a property owner finds that they have an endangered species on their property, before anyone else can find out, because of the potential penalties and because the way that it limits what you can do on your private property and also increases the cost, that you have the incentive to destroy the species before it can be discovered, and then you can be put under the regulation. And that's what I partly talked about at the beginning about, the negative punitive focus of the ESA, where I think you would have better policy outcomes if you revised it to have, a more positive incentive, based type thing. Enforcement of it, I think it's going to largely continue the same, but I don't think that it's getting to the best results as you're disincentivizing the people that are regulated to comply with the regulatory scheme because of the costs that are on them, really, I'd like to see a whole lot more delegated to the states. Several thousand species that are protected under the Endangered Species Act, about 2/3 of them are intrastate species, which I think should be within the state's purview, not the federal government's purview. So a long-winded way of saying, I don't really see that it's going to change that much, but I just see that there's already so many problems that present with the statute that I'm sure COVID will complicate like anything else.
So students, go ahead and feel free to type in any additional questions you have. I realize that, you both sound that you think states should be playing a larger role, right, and regulating, and especially with respect to animal welfare. But I haven't been following it, and students may be curious. Do you think there's likely that there's going to be any legislative response from Congress in the wake of sort of Tiger King? I mean, is there any sort of push at all for there to be? Yeah.
There was actually. There was a bit of a movement. So the bill that Carol Baskins was talking about and going to Congress throughout the whole series, that was sort of dead before the show even started airing. Okay. And it got a second wind, essentially breathed into it, where it actually got taken back into Senate panels and discussions. Whether or not it actually gets passed, it would fall into a long line of those types of bills that are specifically geared towards big cat welfare in captivity that have sort of been raised and fallen by the wayside in the last couple of years. So I wouldn't be surprised if it sort of fell by the wayside, but it did get a little more attention and a little more movement after the series aired.
I don't think you're going to see Congress reopen the Endangered Species Act anytime soon for a couple of just practical reasons. One, I don't think that your ENGOs, your environmental non-governmental units, want to risk that, because in a lot of ways, the Endangered Species Act has been weaponized, and I think has gotten away from original purpose of conservation to a way to, attack infrastructure and development and other types of projects. I mean, anytime that you hear, it's huge business. The Endangered Species Act compliant is big business in the cost of hiring experts and to be able to go and come up with these mitigation plans and whatnot, the cost of developers, but also, under its current format, the ability when there's a pipeline or a highway or whatever, through the citizen suit provision, these groups are able to come in and sue and really jam up these projects, that they disagree with, when a lot of times you're talking about just really, really insignificant type species. So I think that there would be the fear that if the ESA was opened up by Congress, that some of the ways that it's being abused or used that was not really the purpose when the ESA was first adopted would be reconsidered. So they would try to block that. And the second thing is that really about flyover country. We talk about Texas, you talk about, the states in between the coasts, the population differences from where you see the Endangered Species Act really being applied are very different than where the voting membership and the populations are in the legislature. Where you look of, the East Coast and the West Coast, and you look at, East and Mississippi, it's interesting where there's a lot of Endangered Species Act issues aren't where there's a lot of representation typically. And so I don't think that there, is much appetite for the majority of the members of Congress to want to take this on, because it's not something that really affects their district or affects their constituency. And so I just think that the sides have kind of fought themselves to a draw, where you're going to see some regulatory reform and some rulemaking, but really it's stuck that way, and it's just going to be that way in statute for the future.
Well, if there's no more student questions, I'll go ahead and just ask the last question and we'll wrap up. So I'm really curious, so has there been Commerce Clause challenges to the ESA, and how have those fared kind of historically? Since you both seem to suggest a lot of this is intrastate, right? Have we seen a lot of pushback on that in the courts yet?
I'm litigating one right now. We're working on our cert petition. It's actually involving this cave spider species that we challenged, and we're going to have to go up on cert because we lost at the Fifth Circuit on limitations and jurisdiction. The species was listed more than 20 years ago, and typically you have a 6-year statute of limitation for bringing constitutional challenges. We argue that was kind of ongoing when you have ongoing constitutional violations, but we were poured out on that basis. So we have to take that up. But that is the issue that we're litigating right now, is challenge the constitutionality involving this cave spider species. There was a case a few years ago involving a prairie dog in Utah, the intrastate species, where Pacific Legal Foundation, the trial court, won and declared that that was unconstitutional, but they got reversed on appeal to the 10th Circuit, and the Supreme Court denied cert. So it's out there rattling around. I hope our case will continue to proceed forward, but it is an issue that's being litigated, and I think presents some real interesting constitutional questions.
Yeah.
Stephanie, yeah, you get the last word.
Yeah, so there have been a number of Commerce Clause challenges to various ESA regulations. And just out of curiosity, because Rob and I did not talk about this beforehand, but is that the bone cave harvestman?
It is. It is. Y'all did an amazing amicus brief in that case. So
I worked on that in very early days with Rebecca. So it's definitely a fascinating case, and definitely a really good case for a challenge to the Commerce Clause reach of the ESA, because it truly is just this cave spider that occurs in one spot, has no commercial value, but costs developers and private landowners a significant amount of money year after year. But for all of those Commerce Clause challenges to the ESA over the years, in the last decade, the Supreme Court really hasn't shown an appetite for taking up those challenges. And you've seen various circuits take up those challenges and either shut them down or just sort of pass over them and leave the trial court decision standing. And we may start seeing a shift in whether or not there is an appetite for it in the next couple of years. I mean, certainly we have the Supreme Court seat open at the moment, and that could be a big factor in whether or not the court is willing to take up those challenges.
So I think that's all of our time that we have today, but thank you very much, both Stephanie and Rob. It was a really interesting discussion, I'm sure. I know I learned a lot, as I'm sure all of our students did. So thank you very much.
Yeah, this is great. Thanks for having me.
Yeah, thanks for having me as well.
Thank you to everybody. Thank you, Professor Wasserman, for moderating. I think we're going to give Alexis Winter a chance to pitch Baylor FedSoc as well, if you're still on, Alexis, and then we'll close it out. So, or maybe not. So I'll just close and say thank you, everybody, for coming. Appreciate it, and consider joining the Federalist Society at UT or Baylor. I think, yeah, reach out to the folks at Baylor as well if you're interested in joining there. So thank you, everybody.
Thank you. Oh, there she is.
Hi, everybody. I apologize. My video feed was cut off, but I very much appreciate y'all's time today. I do think it was a very edifying discussion, and particularly contemporary given this Tiger King phenomenon. I want to thank also the attendees, Baylor Federalist Society. We put our email in the chat, so if you're interested in joining, go ahead and shoot us an email. We have our next event's just this Wednesday. I'm looking forward to seeing everybody there. Thank you, UT, for inviting us to co-sponsor with